Hi! In this lesson, we're going to talk about Article 3 of the Real Estate Code, which deals with regulation of licensees. The first thing we want to talk about is handling money, disposition of funds. And what Arizona law says is that once we receive money from clients, that we're supposed to deposit that money immediately, either in the broker's trust account or with a licensed escrow company here in the state of Arizona. So let's take an example where you receive $5,000 in earnest money from a buyer. And today is Monday. Well, we receive it at Monday at 3 o'clock, so in that example it would have to be turned over to the broker and deposited no later than 5 o'clock on Tuesday. Now what I'd like you to realize is that oftentimes that is impractical. Why? Because the buyer gives you that earnest money, you have the offer, and now you want that offer to be presented to the seller. But the seller is unavailable, or the seller and the seller's agent receive that offer, but they make a counter offer. And you make a counter back to that counter offer, and so on. So this negotiation may go on for a number of days or even weeks. And if you've deposited that earnest money no later than tomorrow afternoon, and the transaction actually never occurs, then the buyer is going to want their earnest money back, and they're not going to want to wait till for that check to have cleared, and so on. So here's what the law also allows. The law also says that the parties may otherwise agree. In other words, if the parties agree that the money should not be deposited right away, that's okay. So typically what many standard contracts used in Arizona state is that the earnest money is not going to be deposited until there is a complete acceptance, or maybe 24 or 48 hours after a complete acceptance by all parties. That way, if there's a negotiation going on for a period of time, the earnest money can be held out from being deposited. Also, the parties could agree that the earnest money is simply non-refundable, that the earnest money is going to be kept by the seller. Also, home builders. Most home builders' contracts specify that the earnest money will not be deposited in escrow or the broker's trust account, but will actually be put into the operating account of that home builder. So please realize, the law says the broker is supposed to deposit it immediately, either in the broker's trust account or with a licensed escrow company, but the parties may agree otherwise. What we're going to look at here are a number of trust account requirements. And brokers have to use deposit slips which identify the transaction, and they have to have itemized information on these receipts. The broker's name, however, interestingly enough, is not required on those receipts. The money cannot be used for any other purpose. So for example, let's say we had transaction A with $5,000 in our trust account, and transaction B had $10,000 allocated to it in our trust account. And transaction A was ready to close. Well, the broker can't take a couple of $1,000 out of transaction B's allocation in order to use it to close transaction A for some reason. So you can't use the money and apply it to any other transaction. Complete records of these financial transactions have to be kept in the broker's office or available for the real estate commissioner. Now, these records may be maintained electronically, but backups of these must be maintained. Brokers have to use GAAP principles in their accounting. That's generally accepted accounting principles. They have to reconcile their trust account balances and their ledgers monthly. Now, how many of us fail to reconcile our bank accounts monthly? Well, brokerage firms are required to reconcile their trust accounts on a monthly basis. Interest must be removed annually. Now, for earnest money, it's extremely rare that a brokerage firm maintains a trust account. In almost all circumstances around the state of Arizona, brokers have the buyers make the checks out to the escrow company, and they deposit the earnest money with the escrow company, so it's not in their trust account. But property management accounts by law must be trust accounts. A trust account, by the way, if we haven't already discussed it, is an account which is really outside the jurisdiction of the business. And the purpose of this is that if the company went bankrupt, money in the operating account would be involved in the bankruptcy, but money in a trust account would be outside of the realm and the jurisdiction of the bankruptcy. So where we actually see trust accounts in the real estate business is in property management. And let's say we have a property management account where the management company is managing, let's say, 400 or 500 units that might collect on a monthly basis maybe $500,000 worth of rent. Well, if you've got $500,000 in monthly rent plus maybe another 1.5 times that in security deposits and so on, it wouldn't be unlikely or uncommon that a brokerage firm would have $1 million or more average balance in that trust account. And the brokers, in most circumstances, actually earn interest on that account. They don't give that interest to the individual clients, but the brokerage firm is allowed to keep that interest. And even if it's a small amount, even if it was only 0.5% of an interest rate that they were getting on that account, that makes up on $1 million average balance, that would be about $5,000. So the broker would be required to remove that interest from the account because that's the broker's money at least annually. And if that interest starts to get close to $3,000, the brokerage firm would have to take it out at that particular point because having more than $3,000 of their own money in a trust account is deemed to be commingling of funds. In other words, mixing and mingling the broker's personal funds or the brokerage company's funds with clients' funds. So keep that in mind. No more than $3,000 of the broker's money can be held in a trust account at any one time. And if the broker is receiving interest, that has to be removed at least annually, but certainly at the point in time where that interest is reaching $3,000. Brokers also can convert funds. Commingling is the mixing or mingling of clients' monies with brokers' monies. Conversion is actually going out and spending it. So they can't go to the beer store, they can't go to Las Vegas or the local casinos and spend clients' monies. They can't go out and buy themselves fancy cars. Now, don't think this doesn't happen, however. There have been a lot of instances where money, especially in property management accounts, has found its way into someone's hands. There was a major case here in Tucson some years ago where a firm, they found there was $1.8 million missing. There was a lady up in the Phoenix metro area. She actually got a debit card on her trust account and was out spending it on vacations and buying groceries and so on. So there are numerous instances where brokers, unfortunately, have converted clients' funds to their own use. Be aware of it and stay away from it. Let's talk a little bit about record keeping. For everything except residential property management, records have to be kept for a minimum of 5 years from the date of closing or termination of the transaction. So closing would mean you had a successful transaction which closed. Termination would mean, for example, the transaction fell through and never closed. So these records have to be kept for 5 years from the closing or termination of the transaction. And these records have to be available for inspection by the Department of Real Estate. As far as trust account money is concerned, only licensees are able to withdraw money from a trust account or have access to a trust account, with the exception of property management trust accounts where an employee, such as a bookkeeper, could actually have access to that trust account. The earnest money type has to be stated in the contract. So in a purchase contract, if you're taking a personal check, it should be listed as a personal check or a cashier's check. Or maybe it was a promissory note. Or maybe it was 2 goats and a cow and a chicken. Who knows? But whatever type the earnest money, whatever form the earnest money took, it has to be stated in the purchase agreement. A salesperson or associate broker receiving monies, the law says that they have to turn it over to their broker promptly, although the statute doesn't define promptly. So you would want to check with your broker as to exactly what he or she wants you to do with the earnest money once you receive that. Certainly rents, the broker will probably have you deposit those if you're in property management, have you deposit those in that trust account in a very short order. Brokerage firms have to maintain a transaction log so that as transactions, as listings are taken, as purchase contracts come in, as buyer brokerage agreements are entered into, that they log them in and set up separate permanent files for these transactions. And the transaction folders have to include the fact that monies were handled properly and complete copies of essential documents such as the purchase contract, the listing, the buyer brokerage agreement, the closing statement in the transaction, and any other documents that the law requires or that the broker would want to maintain in his or her files. In addition, brokers have to review contracts within 10 business days of acceptance. So for example, let's say a listing comes into a company. The broker has to review and initial that listing agreement within 10 business days of that being taken by the salesperson. Or a purchase contract is negotiated between a buyer and a seller, and the agent brings it into the office and turns it into the manager. The broker has to review and initial that within 10 business days of the contract date. Now, this review by the designated broker or by the associate broker who has delegated authority does not validate or invalidate the contract. What I want you to realize here is that this review and initialing of the contracts is required as an administrative procedure to make sure the broker knows what's going on in her or his office. It has no effect on the validity of the contract. So if a broker fails to initial the contract within that 10 business days, that does not render the contract invalid. The contract is still just as binding on the parties as it would have been whether or not the broker initialed it and reviewed it. Last thing I want to mention here is rejected offers. Rejected offers, buyer makes an offer, seller rejects it. Buyer makes an offer, seller counteroffers. Buyer rejects that. Those are all rejected offers. They have to be kept for 1 year. So once an offer is rejected, a broker has to take that offer and put it in a file someplace, keep it for 1 year. If, however, within that year, that transaction revives itself and a transaction occurs on that particular property between those parties, then that rejected offer has to be taken out of the rejected file and put in the 5-year permanent file. So rejected offers have to be kept for 1 year. Other transactions, once they're closed or terminated, they have to be kept, records have to be kept for 5 years from closing or termination. Let's talk about employment agreements. Now, by definition, if you look at your course material, by definition, an employment agreement is a contract, an agreement hiring a broker to help someone buy or sell real property for compensation. What that really boils down to is either a listing agreement or a buyer brokerage agreement. And the law states that they must be clearly written, that they fully set forth all of their terms and conditions, that they have a beginning date and, very important, an expiration date, because these things expire at midnight of the expiration date, and finally be signed by all parties. So those 4 things again are clearly written, fully set forth their terms, have an expiration date, and be signed by all parties. Employment agreements also cannot be assigned to a third party without the consent of all parties. For example, you're a salesperson, you work for a brokerage firm, and you have 3 listings on properties, and now you want to go over to a different brokerage firm. Can you take those listings with you? The answer is no, because those listings are contracts between, you got it, the seller and the broker. Therefore, both the seller and the broker would have to agree to allow you to transfer those listings to the company, the new company that you're going to. So you can't assign, or they cannot be assigned without consent of all the parties. One of the things that you might be interested in knowing is that in the licensing statutes, the law does say that real estate licensees do have standing to go into court to sue for their commission. So if a brokerage firm feels that they're owed a commission that has not been paid, the brokerage firm can go ahead and sue that seller or buyer or landlord or tenant, as the case may be, in civil court. They have to demonstrate that they were licensed at the time the claim arose. So remember we talked in another lesson about licenses expiring? Well, as long as you were licensed when you put the transaction together, then you're entitled to your commission, even though you might not be licensed at the time the commission is paid. So the question is, when you earned the commission, were you licensed? If the answer is yes, then you were licensed at the time the claim arose, and you would be entitled to receive that compensation. Also, disputes between licensees regarding commissions are not heard by the Department of Real Estate. So let's say that two brokers are squabbling over a commission. First of all, they cannot allow that dispute, that commission dispute, to jeopardize the transaction. So what needs to be done here is the brokers let the transaction close, and then to determine the outcome of the commission dispute, they have to go to court. The real estate department will not listen to or hear any complaints between brokers regarding commissions, regarding the splitting of commissions between brokers or between salespeople and the brokers they work for. The real estate licensing law happens to list about 30 different reasons why someone could have their license denied, suspended, or revoked. Now, we're not going to go into all of these here. They're in the resources in your material. But of these 30 reasons, they range from things which might seem as trivial as placing a sign on an owner's property without their permission, all the way down to major crimes, murder and larceny and so on. Please realize that if the real estate department is trying to deny, suspend, or revoke someone's license, that there is a hearing process that they would have to go through. And the licensee or potential licensee may have an attorney represent them at that hearing. The commissioner can also issue what's called a cease and desist order in order to stop what they're doing. So if the commissioner were to find that someone was acting or practicing outside the bounds of the law, the commissioner could issue this cease and desist order. Can anybody receive compensation in real estate? Well, let's take a look at how you might be compensated. Sellers and buyers and lessors and lessees and consulting fees and referral fees and finder's fees, they can all be paid to a real estate salesperson, can't they? You got it. The answer is no, they can't, because salespeople cannot be paid directly by anybody other than their broker, right? So, but all of these fees can be paid to a licensed real estate broker. So sellers can pay brokers, buyers can pay brokers, and brokers can receive consulting fees and finder's fees and referral fees from other real estate agents or other persons that they might perform real estate services for. So let's talk about how a broker can be paid. Brokers, of course, can pay other brokers. So this is typically the way multiple listing service works. Broker A, the listing broker, agrees to cooperate with and share commission with broker B. And then the brokers each individually pay their salespeople or their associate brokers. Can a salesperson pay another salesperson directly? The answer is no, they cannot. All compensation has to come from whom? From the employing broker. Always from the employing broker. Salespersons may receive compensation only from their employing broker and may pay no one. No exceptions, they can pay no one. And it's illegal to pay unlicensed persons. So, if I wanted to pay somebody who was not licensed to perform some real estate service for me, I would actually be acting outside the law because I'm paying that unlicensed person for an activity requiring a real estate license. It's also illegal for an unlicensed person to receive compensation for real estate activities. So that unlicensed person who is going out and representing themselves as a real estate agent, they are breaking the law. the unlicensed person who's receiving referral fees for directing prospects to a real estate agent, for example, is breaking the law. So let's say that you know a lot of people around town and you tell all your friends that, hey, if you refer some people to me and I close a transaction, I'll send you a check for $500. You would be acting illegally by paying an unlicensed person, and the unlicensed person receiving that fee is actually committing a felony. So keep in mind, unlicensed persons receiving finder's fees, referral fees, or any compensation where a real estate license is required, they're committing a felony. And one of the things that requires a real estate license is assisting or directing in the procurement of prospects calculated to result in the sale, lease, rent, or exchange of real estate. So referring your friends and relatives where you can get $50 off of your next bill on DirecTV, well, DirecTV may be able to do that, but you as a real estate agent can't pay referral fees to your unlicensed friends. Can you pay a referral fee to another licensed real estate agent here in Arizona or in another state for referring business to you? Absolutely, but you can't pay unlicensed people. The last thing we want to talk about here is personal assistance. A number of real estate agents, let's call them the rainmaker real estate agents, they have a lot of business, sometimes can't handle all that business on their own, so they hire assistants. And many of these personal assistants are licensed, which is the way it should be, because as a licensed personal assistant, they're licensed also to the brokerage firm, they can perform any and all activities. So many of these rainmaker real estate agents form teams. They're the top dog in that team, and then they have maybe one or two or three or many other assistants or people on their team who are licensed. Some of them specialize as buyer's agents, some of them specialize as listing agents, and so on. The big problem comes up with unlicensed assistants, because unlicensed people, if they're functioning as assistants, their activities are very, very limited. And their compensation cannot be based on the ultimate sale of the property. So they can't be paid bonuses. They can't be paid because this month or this year there was a tremendous amount of closings within the framework of that team that they work for. They have to receive basically a salary, no bonuses, no additional compensation, nothing based on the ultimate sale of the property. And again, their activities are very limited. The problem is that unlicensed assistants might be asked questions by consumers where they would have to have a real estate license to start answering those questions. So it's very easy for unlicensed assistants to kind of step over the line and start functioning in an area which requires a real estate license. So that concludes our discussion here of Article 3 of the Real Estate Code, Regulation of Licensees.